our legal counsel, the Southern Coalition for Justice, represented by Attorney Anita Earls, and our own legal redress chairman, Attorney Irv Joyner, are formally filing an appeal to the recent decision regarding redistricting by the lower court. We are four of the most historic civil rights and social justice organizations in this state, represent the interests of literally thousands upon thousands of North Carolinians. We know, without a doubt, that the battle for voting rights is a battle that we must fight, and we will win. We know we're in a battle for the ballot. It is a political war, a struggle, a clash of ideas and ideology between regressive desires to take us backwards and a progressive agenda that desires to keep moving us forward toward a more perfect union. We know that any time there's an attempt to segregate, isolate, steal, or suppress the ballot, it is a crime against democracy itself. The founder of one of the founders of the NAACP, W.B. Du Bois, said nearly over 100 years ago, and it is still our mantra today in the NAACP, that the power of the ballot is needed in sheer defense. Without it, what else will save us from a second slavery? Without full access to the ballot, we become slaves to the rule of money, slaves to the rule of political meanness, and slaves to the rule of extremism. And we will not go backwards. Without access to the ballot, protection of the 15th Amendment that says no one can deny the right or bridge the right to vote, the 14th Amendment, equal protection under the law. Without the ballot being protected, then we find ourselves in a place where money wins and meanness wins, and we cannot in this moment stand for this. As we come here today on the steps of the Wake County Courthouse to file this appeal, we file it, these four civil rights and social justice organizations, and I want to emphasize this is not a partisan issue. The courts brought the two cases together, but this case is about civil rights and about voting rights. It's not about Democrat or Republican. It's about whether or not we allow all people to vote, and whether or not we allow people to vote in ways that give them the ability to choose the candidates of their choice, whoever those candidates might be. The lower court's decision upheld the obviously racial gerrymandering voting districts designed by the extremist operatives from the National Republican Party, based on the perverse legal theory that the Voting Rights Act gave the court no other choice. The maps that we are appealing, we appeal them because it is an attempt to say that legalized segregation in voting is constitutional. We believe that is a misinterpretation of the law, and our lawyers will argue such. The courts did not disagree with our facts. They disagree with our interpretation of the law, and we believe that this needs to be fought as much and as hard and as high as possible. This decision is disturbing because it is upholding, first of all, a remedy for African American voters and other minorities that no African Americans or other minorities asked for. So it is an attempt to do something that the affected community has not even asked for. It is internally inconsistent. It weakens and undermines the political influence of Black North Carolinians, not just to elect African Americans, but to build coalitions to elect candidates of our choice. It packs voters of color to our own districts as if people of color don't know how to build alliances and friendship with white voters. and it makes it harder for all people to be a part of the political process. Let us be clear and let it be known without any doubt or any contradiction. Voting rights is a battle we must fight, and it is a battle that we will win. Unfettered, unhindered, unabridged access to the vote and the political power is all we want, all we desire, and everything we will demand. Let me have my friend from the League of Women Voters come now and introduce herself and address us, and then the attorneys will come.